Welcome to the McNees Family Law Podcast Series. This episode is an overview of divorce law by Paul Helvy, Attorney at Law. Mr. Helvy is a member and chair of the Family Law Group at McNees, the immediate past chair of the Family Law Section Pennsylvania State Bar, and was named Best Lawyers 2016 Family Law Lawyer of the Year for Harrisburg.
Hello. I'd like to review the law that affects couples going through divorce in Pennsylvania. There are really three potential lawsuits that you may have if you're going through a divorce, and that is a divorce lawsuit, a custody lawsuit if you have children, and a support lawsuit. Although they are very interrelated, they are dealt with by three different aspects of our court system, so it's helpful to think about them one at a time. Today I'm going to focus on the divorce lawsuit. The first step in the process is the filing of a divorce complaint. It is not terribly legally significant who files that divorce complaint, but it must be filed, and notice of the filing must be provided to the other side. They have to get a copy of it. Once that is done, there are really two primary hurdles that must be overcome in order to obtain a divorce. The first hurdle is proving that you are legally entitled to a divorce. There's three ways to do that in Pennsylvania. The first and easiest way is for the parties to agree, and they do that by signing a document called an affidavit of consent. If that is done, the first hurdle is taken care of. If one or both of the parties refuse to sign an affidavit of consent, the second no-fault way, is to wait 2 years from the date of separation. At the end of 2 years, you can file a couple of documents, and then the hurdle is taken care of. And if you don't want to wait 2 years and parties won't consent to a divorce, you can pursue fault grounds in Pennsylvania. Some people believe that there are no fault grounds in Pennsylvania. There are. And the two primary fault grounds are adultery and sort of a catch-all fault ground called indignities. Typically, we don't spend too much time and energy on that first hurdle because a good deal of our focus is on the second hurdle, which is the economic component of a divorce. And there's really two parts to that. The first part is equitable distribution of the marital property. Note that I said equitable, not equal. And whether the distribution of assets is equitable or not is determined by a list of factors set forth in the divorce code. Marital property is any property that is acquired from the date of the marriage up until the date of separation, with the exception of any property that may have been acquired by gift or inheritance. So, one of the best things that you can do when you meet with an attorney is to create a list of all of the assets that you own and bring in documentation with regard to those assets. For example, if you own a house, it would be helpful to have the deed to the house. And if you have a mortgage on your house, bring in a mortgage statement that shows the principal balance on that mortgage. If you have bank accounts, it is helpful to bring in bank statements showing the value of those accounts. Ultimately, what your attorney will do for you is create a list of the marital assets, help you determine the value of those assets, and at times it's necessary to hire an expert to assist you in determining the value of those assets, and then we'll assist you with the process of negotiating who will get which of the assets that were accumulated during the course of the marriage. If an agreement can be reached, that can be drawn up in a legal document, often called a marital settlement agreement. And if an agreement cannot be reached, then the question of who gets which assets or which debts can be litigated typically before a divorce master. The second economic component to a divorce is alimony. Alimony is awarded to the spouse who makes less money in the event that that individual's reasonable expenses are greater than their income. There is no formula for alimony, and there's no formulaic approach to determining whether alimony is needed or not, or will be awarded or not. And so therefore what you do is you have to figure out the expenses of the lower wage earning spouse, figure out what income is available to them, and if there is a difference between the expenses and the income, then you look to the other spouse to see if they have excess income that is available to help meet that need. Ultimately, either an agreement will be reached with regard to alimony, or it'll be litigated just as with equitable distribution before a divorce master. Ultimately, after grounds for divorce have been established and the economic issues have been resolved, a divorce decree can be issued. The attorneys at McNees, Wallace & Nurk are qualified and prepared to assist you should you go through this difficult process.